You wake up, walk out to your back porch with a cup of coffee, and look out over the river that defines your property line. It's peaceful, until you realize that over the last decade, that river has slowly crawled 20 feet closer to your house. Here is a shocking legal truth. As that water moved, your property line moved with it. While you were sleeping, you literally lost 20 feet of your wealth to the current. Most homeowners believe that land is a fixed, permanent coordinate on the surface of the earth, something that can be pinned down forever on a map. But in the world of real estate law, there is a specialized concept known as an ambulatory description. This refers to property limits that do not have a fixed position because they are tied to features of nature that are subject to change over time. If your deed says your land extends to the bank of the river or the shoreline of the lake, you don't own a fixed point in space. You own a boundary that is alive. This creates a massive legal trap because your property lines can change through two very different natural processes: slow, imperceptible movement and sudden, violent shifts. The slow movement is governed by the principles of accretion, erosion, and reliction. Accretion is when the water slowly deposits soil, actually adding land to your parcel, while erosion is the slow washing away of your dirt. Reliction happens when the water level of a body of water permanently recedes, uncovering new land. In these cases, the law generally says that the owner of the upland parcel gains or loses land as the water moves. But then there is avulsion. This is the curiosity gap that catches people off guard. Avulsion is a sudden, perceptible change in a water boundary, like a massive flood that causes a river to abruptly jump its channel and carve a brand new path through a field. Unlike the slow crawl of erosion, a sudden avulsive change might not legally shift the property line at all, depending on the specific facts of the case. So, where exactly is the line right now? To find out, you have to look for the ordinary high water mark, OHWM. This is one of the most important concepts in water-related property law, and it is a common misconception that it's simply where the water is today. Legally, the ordinary high water mark is the line which the water impresses on the soil by covering it long enough to deprive it of terrestrial vegetation. This means a surveyor isn't just looking at the water, they are looking at the trees and the dirt. This was a central issue in the landmark case of Howard versus Ingersoll. The case involved J.H. Howard, who built a dam across the Chattahoochee River, which formed the boundary between Alabama and Georgia. The rising water flooded a grist mill owned by Stephen Ingersoll. The entire dispute rested on where the state boundary, the riverbank, actually was. The Supreme Court eventually helped define the bank as the elevations of land that confine the waters when they rise out of the bed. They looked for the line where the action of water was so constant that the vegetation changed from terrestrial to aquatic. This leads to a fascinating vegetation test used by experts. If you have a cypress tree on your property, does that mean the land is yours, or is it part of the riverbed? Some courts have argued that cypress trees can be terrestrial, while others have debated their status as aquatic species. In the case of Zunamon versus United States, the court had to decide if certain trees like willow and bitter pecan were aquatic simply because they could survive being flooded for 6 months out of the year. The court ruled they were not because the soil was dry enough during the other 6 months to support agriculture. You might be thinking, I'll just check the county's online map to see my lines. This is a dangerous mistake. Most people rely on GIS maps, geographic information systems, thinking they are looking at a digital, legally binding fence line. But GIS maps are merely for general location. They are not precise, and they are not legally binding. They don't reflect the physical reality of a shifted river or a moved shoreline. The only thing that connects the strange words in your deed to the actual dirt you are standing on is a professional survey. A licensed surveyor goes out and physically locates these boundaries, checking for the OHWM, or the thread of a stream. If you skip this to save a few $100s, you might find out too late that the boat dock you just built is actually on your neighbor's land, or even on state-owned sovereignty lands beneath navigable waters. And it isn't just water that moves. Your property lines can shift due to artificial boundaries as well. If your land is defined by a roadway or a utility line, those features can move over time due to official government actions or even unofficial activity. If a road is widened or a center line is shifted, the location of your boundary on the date the description was written is usually considered the best evidence of where your line should be, but it still requires a surveyor to prove it. The consequences of ignoring these moving lines can be devastating. Take the case of Boles versus National Development Company. Buyers were promised lots surrounding a beautiful 30-acre lake. But the developer failed to construct the lake properly, and it wouldn't hold water. The centerpiece of their investment turned into nothing more than a 30-acre hole in the ground. Their property values plummeted because the physical reality of the land didn't match the legal promises they relied upon. So, what are the lessons for any property owner? First, realize that if you live near water, your property line is a living thing. Never assume that the dirt you see today is the dirt you will own tomorrow. Second, understand the ordinary high water mark. If the vegetation on your land is changing from grass and oaks to reeds and water lilies, your legal boundary is likely retreating toward your house. Third, never trust a GIS map or a street address to define your wealth. The legal description in your deed and a physical survey are the only things that matter in a courtroom. Finally, be aware of wild instruments or errors in the public record. A simple typo in a deed, like writing North 37 East instead of North 57 East, can make a property line fail to close, meaning your legal boundary doesn't even return to where it started, leaving your ownership in a state of legal limbo. Your land might feel solid, but under the eyes of the law, it can be as fluid as the water that runs beside it. Understanding these ambulatory descriptions is the only way to ensure that when you wake up tomorrow, your property hasn't moved while you were sleeping. Thanks for watching the legal lecture. If you found this helpful, subscribe for a new video every week and leave any questions in the comments. See you next time.